HOAs, woo! So tonight we're going to be talking about required and recommended policies. I'm going to be talking to you about the required policies. When we talk about required policies, we're talking about the policies that are required by law under Kiowa, which is the Colorado Common Interest Ownership Act. If you are thinking, wow, Amanda, I haven't been able to sleep lately, you can go to our website and download your own copy of Kiowa, which is Title 38. It's fascinating reading. It'll work better than any type of sleeping pill you may end up taking. At any rate, under Title 38, 33.3.209.5, it lists the requirements, the required policies that an association must have in order to be compliant with the law. Now, this is going to apply whether you are a Kiowa community, which are those communities created July 1st of 1992 to the present, or whether you are considered a pre-Kiowa community, which is a community that was created prior to July 1 of 1992. Now, if you are what's called a Kiowa exempt association, so we do have what are called Kiowa exempt associations, which tend to be, for example, those associations that meet the requirements under the statute. They're very small and they have limited expense community, or they're commercial and written where their declaration is in such a way that they're exempt from all of Kiowa. Then that would be the one type of community that these policies do not apply to. However, I will tell you, sure, I'm sorry about that. I will tell you that, how's that better? Okay. So I will tell you though that if you are, even if you're a Kiowa exempt association, that it will behoove you to put these policies into place or something akin to them, because when we tend to get in front of the courts already have tons of things in front of them, and it becomes very difficult for a court to differentiate between pre and post and exempt Kiowa and which parts of the law apply and which don't. Also, it looks like they're looking for a separate basketball player if anybody's interested. Okay, so best practice for Kiowa exempt is to go ahead and do the policies. So we're going to be talking about the 9 policies. They are the adoption of policies policy, alternative dispute resolution policy, collections, of course, conduct of meetings, conflict of interest, covenant enforcement, inspection of reserves, inspection of records, investment of reserves, and reserve study policy. And I'm going to go through each one here to give you a breakdown of them. So when we're talking about the adoption of policies policy, that is the policy that you will follow as a board, or that your association will follow when it is adopting any other policy, whether it's the required policies or whether it's the recommended policies that Melissa is going to speak about. The policy for adopting policies has to set forth how the board does it, what notice is provided to owners, whether there is a comment period for owners prior to the board adopting the policy, etc., including how the board then notifies the community of the policy. Now, the policy itself, by statute, is going to have general provisions regarding these. However, your own governing documents, usually in either your bylaws or declaration, occasionally in the articles, it may have additional requirements. It may say that you have to give notice to everyone in the community via certified or registered mail or via first-class mail of the policy prior to the board adopting it. It may also say that they have to have that policy 10 days before the board adopts it, or 30 days before the board adopts it. So, in a perfect world, your adoption policy would reflect those requirements that are already in your governing documents, at least to the extent that they're still legal. Some of our documents get a little old and out of date sometimes. But just in the case that you drafted it, or it's been a while since you had your policy drafted, go ahead and give the documents a check just to make sure that there's not additional requirements such as those notice requirements. Now, in general, of course, when you do adopt a policy, you're going to allow the homeowners opportunity to comment on the policy. Some won't, they don't care, or think, well, it's not going to really pertain to me because I don't, maybe I'm not behind in assessments, don't need to worry about it. Others might show up and you'll get an earful as to what they like and dislike about the policy. So policy number 2, that's your alternative dispute resolution policy. What this means is, it's an ADR policy is how we refer to it. It is basically a policy that says that the association is going to meet with owners to try to resolve an issue informally, rather than going directly to a lawsuit brought by either the association or the owner. Alternative dispute resolution can involve mediation, which is where you sit down with a neutral third party and try to work out the disagreement. It could involve just the owner and the board, where it's just those parties attempting to reach a resolution, or those parties and their attorneys. And it could be a bit more formal if it's arbitration, which is where there is a third party administrative law judge. In the event that you have dispute resolution with an administrative law judge or an ALJ, then that decision could be binding. So if you engage in a more formal alternative dispute resolution, such as arbitration, just be aware that while mediation, if you reach an agreement, great, but in arbitration, it's kind of, it's like junior court almost in a way, where you have that decision and it's binding on all parties. So an ADR policy is going to set forth the process for determining if ADR will be used, who it applies to, what the process is, and whether there's any cost involved. Perhaps clearly if it's between the board and the owner and it's just an informal sit down, it will probably not be at a cost to the owner. Certainly if you use a mediator or an arbitrator, you will end up bearing the cost of both. There was a bill this past year that did not pass the legislation that would have required mandatory ADR by associations, with the association and the owner splitting the cost. I don't know if we're going to see that bill come up again. Right now, like I said, it's not passed, but keep an eye out for that. So with ADR, your ADR policy, again, under the statute, just has to be a policy that sets forth this process for resolving disputes informally. However, your governing documents may go a bit further. So in your declaration or bylaws articles, again, for example, you might have a provision that states that owners in disputes with other owners have to engage in some form of ADR. It might also say that the association and the owner agree to mediation prior to any lawsuit, or to arbitration, or to some other specific type of alternative dispute resolution. So again, in a perfect world, the ADR policy is based on those governing documents and would incorporate those. But every once in a while we find one where the policy is written over here and the documents say something more specific. So you will want to double check that. Now, interestingly enough, and you will see this in a couple different policies, while Kiowa encourages the use of alternative dispute resolution, as I mentioned, it does not yet require it, especially because that bill didn't pass. So it requires you to have the policy, but the policy itself doesn't require you to engage in it. Usually the policy will say something like, the association shall make reasonable efforts to comply with the owner's request for alternative dispute resolution. Again, unless your documents require something else. All right, so collection. This has been a big one because it's been in front of the legislature and in front of the news for what seems like decades and has only been a few years. But beginning in, gosh, it was 2012, I think, was the initial big good governance kind of revision by the legislature. And then in 2022, there was another one to collection and covenant enforcement in particular. 2024, we again saw changes to collection, and now 2025, as of October 1st, your association should have yet again another updated and revised collection policy in place. So, collection of assessments. The policy itself has to specify due dates. It has to, when the assessment is due. So we're talking about annual assessments, whether you pay them annually, quarterly, or monthly, but your common expense assessments. When they're past due, when they're past due, late fees and interest that may be charged to a homeowner's account when they are past due, return check charges, and then in repayment plan. Some of you who have been involved in the association for a little bit longer than others will remember that it used to be a lesser payment plan. It's a 6-month payment plan, and there was like a 9-month payment plan. Well, now it's an 18-month payment plan. So this all has to be specified in the policy. Now, where do these numbers come from? When it comes to interest rate, HB 22-1137, which was the bill that was passed in 2022, capped interest rates at 8%. So regardless of what your declaration or bylaws say, what your governing documents say, your collection policy and your association cannot collect over 8%. If you're one of those associations that has a collection or a declaration that actually specifies a lesser amount than 8%, then charge the lesser amount. The statute doesn't say, great news, you can go up to 8%. The statute says you cannot charge more than 8%. When you're charging late fees, your declaration is going to specify a couple things. usually. It will usually specify what kind of time frame your assessments are on. Sometimes it'll say assessments are monthly, due on the first of the month. Sometimes it's a little more generalized, where it'll say something like assessments are due at a date and time to be determined by the board. It'll also have that delinquent date in there. It'll say assessments are considered delinquent on the 10th day after they're due, or on the 20th day after they're due. And you will also often find a late charge. The late charge sometimes is in the bylaws. In fact, I think I see it more frequently in the bylaws than in the declaration, where it'll say the association shall charge a late fee of fill in the blank here. If your documents do not specify a late charge, then you can still charge a late fee under Kiowa, but don't go crazy with it, because we're seeing a lot of kickbacks from the court. If your documents, even if your documents say something like you can charge daily late fees, I would not do that. But certainly if they allow you as an association to pick a late fee, don't do something crazy like a $100 late fee on a $25 assessment. It's not going to look good for you. The court's not going to like it. It just gets us into all kinds of trouble. Return check charges, those are set by statute. It's a different part of the statute, different part of the law than Kiowa. Return check charges, the statute for that says that they have, if somebody bounces a check to you, they have 20 days to return the check, to offer a replacement check, and then they're capped, you are capped from seeking damages. It's the greater of the amount, it's like treble damages plus the amount they owe you, right? So 3 times whatever like if the bank charged you $20, for example. Your declaration sometimes will have out-of-date information about return check charges, and when we're drafting these policies, you guys will call up and then you'll say, well, what the heck, did you not read the documents? It says over here we can charge $150 for a bounce check. It's not what the statute says, so you won't be able to do that. Okay, now on, yes?
I do have a question on the 8%, on the 18 months or whatever. What is that charged to them annually on those payment plans, or is that just?
So when we get to the payment plan, which is now the 18 months, so your documents, if they specify that the late charge is annual or monthly or quarterly, then you have to charge it based on what your documents say. If your documents are silent and just say you can charge a late fee, then generally we see it imposed monthly for every month the assessment's delinquent. So if you were delinquent in January, then February you'd have a late fee plus the January and the February assessment, right? Plus the 8% interest. The 8% interest is calculated per annum, which means that you take the number of days that it was late. First you take 8% and you multiply it by 365 days in a year. And that's going to give you your per day late interest charge. You then take that number and multiply it by the number of days that the assessment is overdue, because remember, it's not necessarily overdue, or sorry, delinquent the next day. It's delinquent on whatever your documents say, so say day 10. And then it would multiply by that. A lot of boards / management companies have software that'll calculate it automatically, which is far easier than me trying to use a calculator and an eraser, a pencil and eraser, but that would be how you would do it. Now with your repayment plan, there's nothing in the statute that really says you can't charge late fees and interest while the person's in the repayment plan, but I will tell you that the courts do not look favorably upon it to charge it while they're in it. So what I would do is one of two things. Either one, I would stop your late fees and interest once the owner enters that payment plan, and then if they finish it successfully, great, you're good. If they haven't, then once they become delinquent on that payment plan and you're getting ready to turn them over to the collection agency or to the attorney's office, go ahead and add that interest and late fee back in because they're delinquent, so now you can put it all back in. Now when it comes to the repayment plan, what the statute says is that the association must offer a minimum payment plan of 18 months, so minimum, not maximum, at a minimum of $25 a month, which is towards the delinquent balance, plus current assessments. So an owner could pay $25 a month for 18 months, plus their $50 a month assessment or whatever your assessments are. And so then a lot of times we get the question, which is, well, $25 a month is not going to pay off the $7,000 they owe the association in 18 months. So what happens then? If an owner opts to take advantage of the $25 minimum payment, they still have to finish it in 18 months. So they can do $25 a month, but when it comes to month 18, they're gonna have a huge balloon payment that's due, right? Because they still owe the delinquent balance. It's just that they're choosing the minimum up until the end of the payment plan. Now, an owner, the board cannot offer less than 18 months. But if an owner proposes less than 18 months, the board can accept it if it wants to. What the board can't do is require a payment plan of less than 18 months. You with me? Okay. Yes.
What if they are delinquent on their monthly payments then?
Yeah, so when you have somebody in a payment plan, when are they basically out of it? When have they screwed up the payment plan? So what the law says is that if they've missed 3 payments, it doesn't have to be consecutive payments, 3 payments, then they're considered delinquent and you can turn them over. 3 payments can be 3 monthly payments. It can be 3 of the minimum payment. It's just 3 payments. If they miss 3 payments while they're on their payment plan, which is whatever they're paying towards delinquent assessments plus ongoing assessments, then they're done. And then what happens? The board has to get together and vote to turn over that account to collection or to the attorney. The way you do that, you can't robo-stamp it. Remember the 06 mortgage crisis where the mortgages got in trouble for stamping things and saying, okay, turn it over for foreclosure. So the statute in 2022 says no, the board has to vote on each one individually. How do you do that? You don't do it in front of everybody and their neighbor. You go into executive session during your board meeting. You say, okay, we're going to look at account such and such. They owe $7,000. All right, I have a motion to turn it over for collection or to the attorney. Yay, nay, you record the vote. And then when you come out of executive and you sign the resolution or record it in the meeting minutes, a resolution is the resolution to turn it over, or you record it in the meeting minutes. You don't mention the owner's name. You don't say Amanda Ashley doesn't pay her assessments, we're turning her over. You say account number ending in 24, or you say you assign them a value or whatever, because when you come out of executive session, that's where you record the vote in your meeting minutes and you want to identify who you've turned over. But of course we want to keep the information confidential, right? So you're going to do it by account number or by some type of number that you know who you've turned over, but that isn't, if or Melissa, I guess in this case, requests records and says, I want to know if this account was turned over, she can't look at it and go, well, I told you Amanda wasn't paying her bills. Instead, she'll go, okay, it was account number ending in 24 that was turned over.
Amanda doesn't pay her bills, so you should all know
This is why I
that.
said she's been in practice 47 years. All right. And it was one bill, no. All right, so the other thing that continues to change with collections, because remember the big one came in 2022, but then 2024, and now 2025, is that the application of payments language changed. So how you apply a payment to a delinquent balance. So previously, and this is still in a lot of your documents, it says when the payment comes in, you apply it to, first to legal fees or collection fees, and then to late fees and interest, and then to fines, and then to the principal or to the arrearage, and then to current assessments. And that has all changed. Now you have to apply it to assessments first and then go from there. So even if your documents have an old way of applying the payments, the law says you have to apply it to assessments first, and then it goes to all of those other fees and interest. That is also to be updated in your new, because I'm sure you've all done them, 2025 policy that went into effect in October. So kind of the I don't know if you'd call it a problem, but one of the things we ran into with the legislation is the bills that came out specify the association has to have a collection policy that reflects whatever these changes are. And if it doesn't, it is not supposed to continue collecting assessments, delinquent assessments, until it has that policy in place. So please get the policy in place. Again, October 1st was when the most recent one came in. Okay, so let's talk about notices. So under the law, you only have to send one notice to the owner, which says you're delinquent. It has an itemization of the balance. It says who to contact if they have questions about the balance, who to contact for a ledger if they want an accounting of their balance, and then, and did I say who to contact for the payment plan? It says who to contact for the payment plan, and it'll list the payment plan terms, so the 18 months minimum $25 a month. That's the only one the law requires you to send. Some of your documents may require you to send additional notices. It may say that there's a courtesy notice, or it may say that the association cannot turn over an account to its attorney until the balance has reached a certain age, a certain time frame. Most of the ones, at least that our office draft, and I've seen very similar ones by other attorneys, will have something like, you get your initial courtesy notice that says you're late after whatever, 10 days, if it's 10 days that the balance is delinquent. And then 30 days, maybe the association sends another one that says, no, really, you're delinquent, here's the balance you owe, here's the accounting. And then at 60 days, the association sends the payment plan letter, waits 30 days, because they have 30 days to respond to the payment plan letter, and then turns the account over. You don't have to do all that. Like I said, you can do the payment plan letter, offering them the 18 months, give them the 30 days, and if they don't respond, then you hold the meeting, you vote to turn it over, and you turn it over. But you do have to follow your collection policy that's compliant with the most recent law. So what you can't and should not deviate from that. You might have occasional exceptions to deviate from a policy because, of course, you're filing liens, for example, right? So let's say you know that this person's delinquent $3,000 and they're selling their house and it's closing next week. Your collection policy will probably allow you to deviate slightly to file that lien ahead of time, for example, so that you can make sure that you get paid from the sale of the home. But in general, we don't want to do a lot of deviations because that's where we run into trouble. So if you find that you have a policy where you're doing a lot of deviation, saying, well, we're going to give them an extra 45 days, then you probably need to revamp your policy so that it just says you're going to give everybody 45 days because we don't want to run into issues of selective enforcement. Okay. Notices. When you send these notices out, most of the time they're going to go via first-class mail unless your documents require you to send notices via certified or registered mail. If they require notices to be sent via certified or registered mail, then your policy will reflect or should reflect that that's how it's sent. You might also, though, because it's going to get very expensive very quickly, you might also want to look at amending whichever document it is that has that requirement to remove it so that notices are sent just general first-class mail. But nonetheless, you have to send them via mail, okay? Even under the current statute, you can't just email the owner. You can email the owner in addition to sending it via first-class mail. If your declaration requires everything to be registered mail, you can, again, also send it via email or first-class mail, but you have to do at least via mail. When it comes to the payment plan letter, so that's the one notice. If you're an association that sends 3 notices, then they go first-class mail except for the payment plan letter. If you're an association that only sends out that payment plan notice, that notice has to be sent out via certified registered mail. Now, up until the 1st, you also had to send that notice 2 other ways, either email, you call telephone, or text. And a lot of people did not have email or phone numbers. So the law now on October 1st said, okay, we still want you to send us. So you're sending that payment plan letter certified mail. We want you, or registered mail. We want you to send it 2 of the 3 other ways. But if you don't have that information from the owner for the email or the telephone, then you can go ahead and also send the letter first-class mail. Okay, so notices in general, first-class mail, payment plan letter, registered or certified mail, as well as either phone, email, or if you don't have those, regular mail. Unless your documents require you to send everything via registered or certified mail. All right.
That's where they, excuse me,
That's okay.
that's where they eliminated the door posting.
Yes, so the door posting in 2022, there was the requirement to post the notice on the door. In 2024, that requirement was eliminated and we had to text, email, or telephone. That has now, it's still there, but you also now, if you don't have that information, can send it first-class mail. With the email and phone information, the association is now required to request that information periodically. There's nothing that says what periodically means. I would do it annually at the very least. It does not mean the owner has to give you that information, but it does mean the association has to request it. So if you request it, the owner doesn't give it to you, and remember, you can then send that payment plan letter via US mail in addition to certified. Okay, and then the other thing that came out of this new 2025 law is your association, as you probably know, is required to register with DORA, the Department of, it's real estate, what is it? Department of Regulatory Agencies, sorry.
I kind of made something
know.
up a little bit more snazzy.
Oh, sorry.
Department of Regulatory
Department
Agencies.
of real cool stuff. And so this 2025 law, instead of just reporting your annual reporting requirements, now requires you to report on additional things, such as in the 12 months leading up to your registration. So when your registration comes around January 1st, it will want you to report for the 12 months, so for 2024, how many payments plans you offered to owners, how many payment plans owners entered into, the number of accounts that were 6 months or more delinquent. It has about 12 different requirements now because part of the bill said, and anything else that DORA may request. And so DORA has come back and said, well, we also want to know the size of your board. We want to know the percentage of late fees and interest that you've waived, and as well as there's an entire list on DORA's website. So the thing with DORA is under that additional information, it has titled it requested information as opposed to required information, but the statute says that it's required information as anything else DORA requests. I don't know what they're going to do with that. They're still sorting it out. Why am I telling you that? Because it's possible that when you go to do this, it may want the information but let you go through it because it's just requested, or it may say, we said requested, but we have to have the information when you're filling out your DORA registration. All right. Phew, that was collection. I'm exhausted. Okay, conduct of meetings. Yes?
Are we talking just dues, or are we talking assessments too, like code violation?
Yep, all assessments, well, so for the DORA reporting, it's just a past due balance in the last 6 months. For your collection policy, it's anything that is termed assessment. So it's going to talk about your due date for your common expense assessments, but when it comes to special assessments, individual purpose assessments, supplemental assessments, fines, for covenant violations, those go on the owner's account, and if that account becomes delinquent, you'll follow that collection policy for the balance, whatever it consists of. All right. Conduct of meeting. Any more questions about collection? Okay. Conduct of meetings. So conduct of meetings is the policy that the board follows when it comes to board meetings and member meetings. It's going to list things such as a nice way of saying, please don't be a jerk at our meetings. It's going to list things like everybody has 3 minutes to speak when they come to the meetings, but the board can raise or lower that as long as it does so equally. Why would it do that? Because if you have 5 people show up and you have an hour meeting, maybe you want to give everybody 5 minutes. But if you have 30 people show up, maybe you only want to give them 2 minutes because otherwise you're going to be there all night. It's going to talk about additional notices for meetings, both board meetings and annual meetings. So for member meetings, it'll say that the notice has to be sent out between 10 and 50 days prior to a member meeting. No less than 10, no more than 50 days. It'll talk about special meetings. So if owners get together and say we want a special meeting, or the board calls a special meeting, what the requirements are for that. It's going to talk about notice for board meetings. It will also speak to whether the board can take action without meeting. So in other words, via email or telephone. Spoiler alert, they can, because the nonprofit code says they can. It will talk about owner input at board meetings. There's going to be homeowner forums. By law, the homeowners are allowed to come in and speak. It'll talk about elections, board action by email we covered, and then of course executive sessions, because there's only certain things you can talk about in executive sessions. You can't just say we want to go in there because the homeowners keep talking. Okay? Don't do that. Also, don't have just an executive session. You can't do that. You have to have a board meeting and go into executive session. If you call me and say we met for coffee and we called it executive session, you're going to get in big trouble. And then you're just going to pay me a lot to try to get you out of it, and now you've wasted all your money. All right, other questions? Chip?
Are there rules about how you report votes by the board in terms of numbers of people on each question? Whether it's
So-
unanimous or whether
Yeah, so in your meeting minutes, when it comes to the board voting in meeting minutes, you will want to record like a motion was made by Carrie and it was seconded by Melissa, all in favor 4, against 3, right? If it comes to an election, so you're at an annual meeting and do an election, then you're going to have different rules depending on if the election was contested. So if there were more people running for a board seat than there were board positions, you have to do it by secret ballot. And so you would count the ballots and report them, and you have to keep them on file pursuant to a policy Melissa's going to talk about later. Sometimes if you just have, let's say, 2 people running for 3 board positions or 2 for 2, then you would vote by acclamations. You wouldn't have to do a secret ballot. You could just say all in favor and everybody votes. But you do want to record meeting minutes that reflect that.
But in general, board meetings, you don't have to say how each person voted.
You want to
give a name.
So it depends on what you're voting on. In your resolution, you'll want to say like there were 4 turnover, 3 against. There's nothing wrong, and I would encourage you to put down like they do, quite frankly, with the legislature, where it says Carrie voted no on this issue. But there's no requirement that I'm aware of.
Does everyone have to indicate whether it's unanimous or not?
No, because by the very recording of the vote, it would show whether or not it was unanimous, unless you don't have all the board members there. Other questions about this one? Yes.
Excuse me, what about Zoom meetings for the board, because we don't have a place to meet?
Yeah, so Zoom is fine, and if you have an updated conduct of meetings policy, unless your declaration or bylaws say something weird, like you can only meet at the clubhouse in the neighborhood or something like that. But most of the conduct of meetings policies say that you can meet electronically and that the member meetings can be electronically. That's not a requirement. That can be at the discretion of the board, again, as long as it applies equally. You could also do business via email under that consent to corporate action or action without a meeting. It's called both, but it's the ability to meet. Now, if you meet outside of a meeting, so you're meeting via telephone or you're meeting via email, first of all, when it comes to records, an owner can request records, including discussions leading up to the actual vote, so anything that pertains to that vote, which means that if you're sending emails that say, I hate this person, so I want to vote no, that can be turned over, so don't do that. Secondly, when it comes to action without a meeting, if you take action via email, you want to, or telephone, you want to ratify it at the next board meeting. So maybe you vote yes to putting in a pickleball court where the basketball courts are. When you have your next board meeting, you'll say, we discussed this via action without meeting provision on such and such date. There was a motion. It was 4 yes, 3 no, whatever. And so you want to ratify the meeting, because remember, before you take that action, homeowners have the opportunity to speak about it. So you want to bring it up then and record it in your meeting minutes. Okay. Conflict of interest. I get a lot of questions about this one because people call and say there's a conflict of interest because he doesn't like me. Maybe, I don't know. But here's what I can tell you. The conflict of interest policy is going to set forth the procedures that the board and the association have for addressing conflicts of interest. When we're talking about conflict of interest, it's generally the financial interest. If there is a financial interest, if I say we need a landscaper and you should hire my brother and he's gonna give me a kickback of 20% every time he mows a lawn, that's a financial interest that I have, right? So I would have to disclose that. Your conflict of interest policy sets forth when a director has to disclose a conflict of interest and what happens after they disclose that conflict of interest. If I say hire my law firm and I'm the president of the board and I don't disclose to you that it's my law firm, then I have a conflict of interest, right? So that's what we're looking at. And it's going, your conflict of interest policy will set forth that procedure. It'll also set forth whether the director gets to even sit in on the meeting then after they've disclosed the conflict of interest, whether they can sit in and sit in and listen, or have to recuse themselves from the meeting. And they're not gonna vote if they've disclosed the conflict of interest, right? Now, if you've disclosed the conflict of interest, there also in the policy is going to be the process for approving or rejecting the transaction. So in other words, does everybody else think it's a conflict? If I say my brother's a landscaper and can give us a deal, and the board says, we're looking at all 3 contracts, your brother, it turns out, is the least expensive and will do the most work, great, we're gonna vote for him, then we're okay. But if I hide it and then say, oh, I got this guy on the side and don't tell you he's giving me a kickback, we have a problem. I talked about whether the director participates in the discussion and or the vote. And then, of course, you want to regularly review the policy. Now, you're going to have a lot of owners who will come forward and say, I think this is a conflict of interest. I had one recently where it's about rentals because they know somebody on the board isn't as much of a fan of rentals as the other board members. And so they want to have that person recused because they don't like rentals. But that's not really a conflict of interest under the conflict of interest policy because the board member does not benefit financially from that whatsoever. He just doesn't like rentals, right? Okay. All right, covenant enforcement, that's another big one that changed most recently in 2022. So your covenant enforcement policy is going to talk about how to enforce violations of your covenants and your rules and regulations. This includes your architectural guidelines. You are going to make sure in your governing documents that you don't have stricter procedures than the law requires. The law requires you, in this policy, to split it between 2 types of violations. There's public health violations, and then there are, violations that threaten public health or safety, and then there are just regular violations. Your policy is going to set forth the requirements for each and what notices you have to have. Now, by law, you have to have in the policy something about giving the owner an opportunity notice and an opportunity to have a hearing before the board about whatever the violation is. It also sets forth the hearing process. The policy might say, well, we give owners 10-day notice of the hearing after they've requested it, of the hearing date, and then regardless of whether the owner shows, the board makes a decision and sends out the decision to the owner in writing, okay, fine. It's also going to specify how notices are delivered. Now remember when I told you in your collection policy, right, some of those notices may have to be sent registered or certified mail besides payment plan, which does. If your document says registered or certified mail for notices, that also applies to this policy. It applies to every policy. So by law in 2022, the law said you have to give an owner 2 separate notices to cure before you can turn it over for enforcement, turn it over to an attorney for enforcement. Each of those notices has to give the owner 30 days. And the maximum you can fine on these violations, on regular violations, is $500. Now, you can do more. You could say, well, we're going to, not more fines, more notices. You can say we're going to give owners a 10-day courtesy notice and then a 30-day courtesy notice and then 3 notices and only fine them $300 at $100 each. Fine, as long as you don't go over $500. The public health and safety is a little different. Public health and safety, you have to give them 72 hours to cure the violation. There aren't a lot of violations that are going to fall into public health and safety. If you are in a community where somebody has had a grill that's been sitting out for 10 years and you've now decided it's a public health and safety violation, you're going to be hard pressed to argue in front of a judge that a grill that's not being used is a public health and safety violation as opposed to a regular violation. Dog poop, we get that one a lot. There's dog poop, that could be a public health and safety issue. Not really. I mean, maybe if it's to the level that you can't breathe when you are, but I mean, it's not a public health and safety. Things that would be public health and safety, a fire. Do you want to send 72-hour notice when there's a fire? No, you do not. You want to call the fire department, right? Okay. These are the questions we get. Okay, so then after you send out the notice, your however many notices you have, most of the policies we write have a 10-day courtesy notice and then the first 30-day notice and then the second 30-day notice if they haven't cured it. You or the manager, your board or the management company, has to go out and has to verify whether the violation has been cured before you send the next notice and the subsequent fine. An owner can write into you and say, hey, we cured it, you should probably go check. Or the owner can send in a picture that says, hey, look, it's cured, you should probably go check. But most of the time, the owner's not required to do that. Most of the time they're not. If I get a violation, this is another, I don't pay my bills and I don't mow my lawn. If I don't mow my lawn and I get a notice in the mail that says, hey, we noticed your lawn is in violation of our covenant that says it has to be, 2 inches of grass or whatever. I have 30 days to cure that. I probably am not gonna call you at day 29 and say, hey, I mowed my lawn. So you, before you start the next step of the process, have to come out, you the board, you the manager, your manager, come out and verify whether I did indeed cure it. Now, the next question we get a lot about the covenant enforcement policy is you used to be able to do what are called daily fines, right? Or repetitious violation fines, which meant if I didn't mow my lawn in June, and then I didn't mow it in July, and you could keep going up and up and up. And now the law says no, if you mowed it, right? So if I mowed my lawn on day 29 of your 30-day notice, and then I let it grow out again in July, you have to send me a new notice. If I park my car illegally, where it's parked, I don't know, in my neighbor's spot, you have to give me notice. I won't get into towing, Melissa's gonna handle that part. But there's certain notices you have to give, and if I cure it, if my music's too loud and you send me a 30-day notice and I turn my radio off, I've cured that violation. So if I do it again tomorrow, it's a new violation. And that's kind of the one big part of this policy we've struggled with the changes in 2022, is that it's removed the ability of the association to really pursue kind of those repetitious violations. And your neighbors aren't gonna like that. Yep.
So if you have a chronic parking violator, and you have, did you say a maximum $500 that you can charge for that? Does that start over again in a year, or?
So you would give the 30 days to cure, and if you reach the maximum 500 violation, then it would depend. If it's cured, then you would start over completely, right? So next year when they do it, if it's not cured, which is gonna be hard with parking violations, if they've just left the car there and you've sent all of the notices, you're going to want to turn it over to the attorney because they're not doing anything, right?
So if they move it.
If they,
temporarily,
right.
and then put it back.
Yeah, now they might say they move it, and how do you prove it wasn't moved, short of either having a camera on it 24/7? The parking thing comes up a lot, especially if you don't own the roads. If your community owns the roads, you have other options like towing or booting. But if you don't own the roads, you can't enforce the public right of way anymore. Yeah, so that helps. Okay, what?
Came to the same issue. Is it possible that a policy can be instituted where they could buy parking space that they're using illegally, let's say? In other words, can we go ahead and say, hey, $40 a month is a standard limit?
So it depends. I know everybody's favorite answer, and this is why. If your declaration, so if the parking spaces are, for example, limited common elements, and your declaration says you can assign limited common elements or that to owners, or that you can charge a fee for what you have authority to regulate parking, then you can develop a policy that says, okay, we will rent you an additional parking space because we have authority to under the documents. But if your documents don't allow the board to assign limited element parking or don't assign limited common element parking, or your documents do not otherwise speak to authority of the board to do something like that, then if you try to, you're going to be challenged on it as soon as you try to collect it. So it's the depends answer because it depends on your governing documents.
And that policy would be the annual meeting item that we're going to have to approve.
If your governing documents do not have authority in them to do that, then you would have to amend the declaration, which would require membership approval, which could be done at an annual meeting or at a special meeting called for that purpose. Okay, so fines, we talked about the $500 cap, the $50 every other day for the public health and safety. Again, public health and safety, short of something like a hoarding situation, most of your public health and safety, or if they're true public health and safety, you're probably not going to want to send the notice and fine them every other day because it's going to actually be a public health and safety issue. But that's your options. And we did talk about the repeat violation. Short-term rental is another one. If you have short-term rentals where it says in your documents that you can't rent for under 30 days, you'll have people who rent their unit out, and as soon as that person leaves for the weekend, then the violation is cured because they're no longer doing it. Or you'll have people who have their Airbnb people sign a contract that says they're renting it for, let's say, a week, but really they're only there, wink wink, for overnight, so they only pay a reduced rate. When it comes to, if your documents specify that you cannot advertise on a site like Airbnb, You will find owners who advertise and then the board sends them the notice saying this is a violation, and then they take it down and so now it's cured, and then they pop it back up again. This has been it's been a whole huge mess, especially we have an entire department that deals with these violations. And they've been real happy about a lot of these. Go ahead.
I noticed you have on there trash cans, that was probably one of the biggest ones, so.
Yeah.
So this week they have trash cans, you write them all, next week they don't have trash cans, then you're gonna start over again.
Yeah, right. Here's the other thing about trash cans. So I live in an HOA, right? So my HOA says you can't put trash cans out on the sidewalk, right? You need to have them off the sidewalk so people can walk, fine. But the problem is my association doesn't own the roads or the sidewalks. So they can't actually enforce that. Now some people know that, some don't, but if it's a public right-of-way, regardless of what the declaration says, the association can't enforce it. So I could have my trash cans out in my driveway, and the association could send me a letter saying this is in violation. But if I move that to the street, the association then gets to call the cops and say, well, I know you're busy, but can you come get this, right? And they don't a lot of times. Like they will if I park my camper out in the street for more than it's like 5 days in a row or something like that, then usually, right, they'll come around. But if it's something like trash cans, they don't tend to enforce as much. So it's been very much a headache. Mm-hmm.
You just spent on a really nice one there, talking about the camper that's parked on the street. So if the HOA says that they don't tolerate having campers, motorhomes, recreational vehicles on the lot.
Mm-hmm.
So if they park on the street, then that really isn't a violation?
It's not a violation of the declaration because you can't, let me take that back. You might be able to say it's a violation of the declaration, but you can't enforce it because it's on the public right-of-way. Now, if your documents say no RVs in the community and you own the roads and they move it from their driveway down to the road, then you can enforce. Yeah, if you don't own the roads, you can't regulate the public right-of-way. That passed in 22 as well.
So everybody
If I
who
remember
has a
correctly.
motorhome or whatever could park it on the street.
Yep. So when the neighbor calls and says, why aren't you doing anything about this motorhome? The association can say, well, we can't regulate the public right-of-way. Please feel free to call the city because it usually is a municipal code enforcement. And I'm going to tell you, a lot of people aren't happy about this because for years, associations have regulated whatever their documents say, right? So if the document said no parking in the street, there's no parking in the street. And then this law came around and said, no, you can't do that anymore. You can't regulate parking, public right-of-way. Okay, inspection of records. Inspection of records is a big one. That one also changed in 2022. Owners have the right to inspect records, to access the records, although there are some restrictions about that. So under 317 of Kiowa, it lists the records that an association must turn over and keep available for inspection, records that the association may withhold from inspection, and then records that the association shall withhold from inspection. The records that they shall withhold from inspection are things like employment records, if they have employers at your association. Things that are required to be turned over for inspection, meeting minutes, voting, if you do a vote, election, you have to hold those for up to 1 year. An owner can request it. What did change in particular in 2022 is that the association now faces penalties if it doesn't provide the records to the owner either within 10 days of the request, or if there is a board meeting being held within the next 30 days from the date of request, it can provide the records there. Now, the association does not have to, it has no duty to compile, to synthesize the records. So if an owner says, well, I want to know how many loan payments we have left on this loan, they're entitled to a copy of that contract showing the loan. They're entitled to the financial statements of the association, but you don't have to go through board and create a spreadsheet that calculates exactly how much interest is left. If you have that, then turn it over, but you're not required to put it together solely for the purpose of the records. Under the records statute, if the association incurs actual costs, so not just this is a pain in the pants cost and I'm going to charge you $50 to do this, but if you actually have to go down and copy a bunch of records because you have it in a box somewhere, you can require that the owner reimburse the association for the reasonable cost incurred by the association. Reasonable means reasonable, right? You can't say it was $1,000 because I went to what is no longer Kinko's, but that's the only one I can think of right now, to make all these copies. Okay? Now, you can require that to be paid up front before the records are sent over to the owner. You also can determine, okay, we're going to send these via email or hard copy, etc. I am going to tell you though, if you have them via electronic form, even if you can choose to provide hard copies, and you just want to do it because you want somebody to pay and you want to kind of, don't do that, because the court's going to say, well, these were in electronic form, you could have just emailed them over at zero cost to everybody, right? Okay. Penalties can be, what is it, up to $50 a day if you fit going back to day 1. So you have 10 days to provide the records. On day 11, if you've not provided them, the penalties can go retroactive to the day the records were requested, daily fines until you give those to the owner. And like I said, the exception being if you already have a board meeting scheduled within the next 30 days, you can ask the owner to come to the board meeting and review the records themselves. And they can take pictures with their phone, or they can bring a portable scanner, or whatever they want. Okay? All right, so your inspection of records policy should contain the penalties, of course, that we just discussed, that you can request a cost for copies, the actual cost incurred, the timing for providing the records. So again, that's going to be the 10 days or the 30-day board meeting, the process for requesting access to the records, how the records can be provided, so let's say via email, hard copy, mail, etc. That's what you want in that policy. And we get a lot of these policy record requests coming in, so treat them seriously. And they don't always come across saying, hi, I'm requesting records. Usually you get an email that says, I want to see such and such. It's still a records request, so treat it as such so that you don't get fined. Okay, investment of reserves. I'm sorry, yes?
How long do you have to keep those files? How long does a management company or an HOA card have to keep the files?
So sometimes your documents specify how long you have to keep them. However, Melissa is going to talk to you about retention of records policies, which will detail exactly how long you need to keep everything. Good job. Yes.
I'm just wondering, if we have a management company, and I guess this inexperienced board has assumed that they have copies of all of these documents.
Mhm.
Is it fair to say, I want to come in and make sure you have all the documents we're required?
Is it fair of the board to ask the management committee that? I mean, it's the board's records ultimately.
Right.
So the board could say, we want to see if you have copies of these records. Yes. Now, back to your question, the management company retaining, you might have a contract with the association that says how long the management company is retaining it. So you will want to look at that contract to see what they have on file. And don't forget that if you've changed management companies, or if it's a new management company that came from a prior board turnover, that sometimes they don't have the records because they just weren't provided. And there's usually provisions in the contract that talk about that, but not always, which, plug for your attorney, is why you want the contracts reviewed to make sure you have those. Any attorney, not just me. Okay, any other questions about that one? All right, investment of reserves. So there's two policies we're going to talk about with regard to reserves: investment of reserves and reserve study. Colorado, this is another one where I said Colorado is going to require the policy but doesn't actually require the matter, so to speak. Colorado does not require a fully funded reserve. Colorado also says, well, we recommend it, but there's no requirement. But what it does require is that you have these two policies: investment of reserve, which is where your reserves go when they're earning money for you, and a reserve study. So even though Colorado does not have a law yet, and I say yet because we've had one pop up a couple times that hasn't passed, about reserves or reserve studies or fully funding reserves, you still have these requirements that you have the policies, and the policies have to specify certain things. In order to meet those certain things in the policies, then you actually have to do the things, even though there's no law that says you have to do the things to begin with. Are you with me? Okay, so investment of reserves. Your documents, it always goes back to your documents. Your documents may specify that reserves have to be invested a certain way. Your documents might also specify what you can use those reserves for. Your documents might say something like you can only use your reserve account for capital improvements, which means you can't just use them because you decided to do the, whatever, pickleball. So your investment of reserve policy should list the purpose of the reserve fund. If there's nothing in your documents, if your documents just say capital improvements or whatever else the board may use it for, great. But if it's specific, this would go in investment of reserve. So what's the purpose of it? What are your criteria for investments? Does it have to be in an FDIC insured account? Can it be in, random stocks? Can you use it in, I don't know, Bitcoin? I don't know that you should do that, but it might say that. And then you want to review it and adjust it as necessary. Why? Because if you have a policy that says you only will deposit it in such and such bank and you no longer use that bank, you probably want to update your policy, right? Because what happens if you're not in compliance with your policy? This is what we usually see. Sometimes you'll see an owner who says, I'm suing because you're not in compliance with these policies, or you're not in compliance with your governing documents of the law. But most often we see it about something completely unrelated, like delinquent assessments, where the owner is being sued because they won't pay the association delinquent assessments, and then the owner's attorney, we all know you love attorneys, so we like to hear ourselves talk, comes along and says, oh, judge, but they didn't comply with this investment of reserve policy, or this conduct of meetings policy, or this policy that doesn't even have anything to do with whatever we're talking about. And they try to convince the court that if you didn't comply with that, you probably didn't do everything else you were supposed to either. And so then that results in you paying your attorney and the other party's attorney. So that's why you gotta be compliant with these. And you also don't want to enforce things that aren't legal anymore. You get into big trouble. Big trouble. All right, so then you have a prudent investor rule, which is if you rely, this is kind of across the board, if you rely as a board member on expert advice, so you're gonna wanna go out and seek expert advice from your tax person, from your CPA, from your attorney, from your landscaper, from your engineer. If you rely on that advice as a board member, then you have kind of shifted that liability that you would have otherwise had to the other person. If I give a legal opinion to you that says you're responsible for X, Y, and Z, and you rely on that, you've done your duty, your fiduciary duty, your due diligence, you've been prudent. If my opinion's wrong, then that's my fault, right? Because you have relied on it as you're supposed to. So it's very similar with the prudent investor rule. Don't do the Bitcoin, right? Unless you want to look and make sure that what you're investing in is good, is strong, is around. It's not a fly-by-night like, oh, well, we heard that this up and coming, TikTok-esque type of thing, and we're going to put all our money in there. Don't do that. All right, then we have that reserve study. So the reserve study is something that the association, if you haven't had one already, you would hire a reserve company that comes out and says, these are the national standards for what an association has to take care of. And then they'll look at your documents and say, what else do you need to maintain? And then they will do a projection based upon, and I'm speaking very loosely here, so the reserve study people who may listen later are going to be like, really, Amanda? But what they do is they go, okay, if you're required to maintain this condominium building, based on what we're seeing today, it would cost X amount. The life of the building is, I don't know, the life of the roof is 20 years. In 20 years, we think it's going to be a projected cost of Z to replace the roof. So based on all of those fund calculations, we think you need this amount to have a fully funded reserve. So in order to care for everything that you as the association are required to care for under your documents, this is how much money you will need to replace whatever that component is at the end of the life of the component. Now, sometimes the components last a little longer, sometimes they fail sooner, sometimes we have freak hailstorms or flooding, right? So it's not an exact science, but that's what it's for. The reserve study policy tells everybody when you're going to have a reserve study. Are you going to do it every 3 years? Have you had one already? Or are you going to do it every 5 years? What part goes into the physical and financial analysis for the study? Who reviews it? Generally the board will come back and say, okay, we're going to every year take it out. You got to think of it as a roadmap, right? You wouldn't say we're going to California and then put your map in the glove box. You want to take it out along your trip to see if you're going the way you should. So the board's going to run it, review it periodically, and have it updated. If it says you'll have it updated every 3 years, then call your reserve company and say, hey, we want to come out and make sure we're still on track with this. And then it's going to talk about when or whether the update is needed and how the reserve is funded. Is it funded through regular assessments? Is it funded through a special assessment? Is it funded because you budget a little extra each year, etc.? Reserves are a big deal right now because, what was it, 3 years ago now, maybe 5, the big condo collapse in Florida. and it collapsed, and a number of people lost their lives, and it collapsed because there wasn't regular maintenance done on the building, and the reason there wasn't is because there was not enough money. And boards in particular don't want to raise assessments because we know that ourselves and our neighbors struggle to pay things anyway a lot of times, especially if you're in a building where there's a lot of fixed income. But the board has a fiduciary duty to keep those assessments going so that it can care for whatever the association is required to care for. Otherwise, you do end up in an issue like the condo collapse in Florida. So Colorado, like I said, keeps coming up with these reserve type bills, and one of them did pass and was vetoed by the governor, so it didn't become law. But we're seeing these come up, and we're going to see them come up again. So have a healthy reserve. I know owners are not going to want to vote for an increase in assessment. They may show up and try to veto the budget, but keep in mind that you as board members have that duty to the association to make sure that you are setting the association up for success. You're also going to have owners who say, I don't want to pay for this because in 5 years I'm going to sell my place and I don't care if you replace the roof on it. I get it. But they're using the roof now, or they're using the component now. So ultimately, they're not creating a reserve to pay for something in 5 years. What they're doing is they're paying for a component that they're using and is depreciating while they're using it. All right, that's my time. Any questions about those two policies? Yes?
I have two questions actually about these reserves. Where do you find a company that will come in and evaluate reserves?
So there's a couple in the state. Certainly you can call any of the attorneys. We usually have a referral list of like, I wouldn't say referral list, but a list of like people we know do that type of work. But you can look up Association Reserve Studies. I know there's Association Reserves is one of the companies that does them. What's the other one? Do you remember offhand? Oh, I had it right
Reserve
there.
specialists
Yeah,
or something.
reserve
yeah.
specialists, and I can't think of the, anyway, you can do a Google search, but I would call your attorney or your manager or a manager and say, hey, who do you have in the area that will do this? And usually we have a list that we can say, okay, here's people we know do northern Colorado, or here's people we know do over here, or whatever, that we've worked with in the past.
How much does that cost?
Yeah, it depends on the components. So offhand, I don't know. I can tell you I just did a class with a reserve study person 2 weeks ago, and his answer to that question was it depends on how in-depth their study is. So if you're an association that doesn't have a lot of common elements, that doesn't have a lot of maintenance obligations under your declaration, then it's not going to cost as much as it would if you're like a large association or a condo association where you take care of everything from the walls out, etc. So they, I believe, will give you some type of estimate ahead of time as to what they believe it's going to run before you do it. And it can be pricey, but then you at least know what you're getting into so you're not accused later of not maintaining.
We do, no one on our board has ever thought about investing money from the reserve account into something that would generate money. Our management company has decided that our reserve account is the savings account for when the accounting department can't pay all of the bills at the time that they're paying bills, and they don't wait until the end of the month. Then they tell us we board approval to shift, say, $10,000 from the reserves, but we need those reserves, and then to build them back up is cumbersome and time consuming, and the owners don't understand.
Right, because then you're trying to repay what you took out plus add to it to build it up. So a couple things on that one. One, you want to check your management contract because it might have provisions about when it can act, what it needs board approval for, etc. Ultimately, it's the association's money. But two, check your documents, because if you do have those documents that say reserves may only be used for capital improvements, for example, then that's not going to fly, right? Because then you're not in compliance with your governing documents. And it's not the board's fault. It's purely the response of we can't do this because we can't legally, we don't have that provision in our documents.
And I can tell that to the management company. You may not just transfer money because our documents state that it's for capital campaigns.
Well,
or
two-
we
two things. So one, if your contract says they can transfer money, then you might have already agreed to them transferring money generally. In that case, what you could say was, look, our documents only allow reserves to be used for these types of expenses, so we can't approve it just to, you know, shift it over for, I don't know, the water bill.
The landscaper, okay.
Yep, and it might be a matter, especially because we're coming into annual budget season, or we're starting right now, of redoing the budget with your manager, right? Work with your manager and say, listen, our documents say this, we know that this is an issue to pay, so we want to increase assessments such that we're able to cover our bills while still funding our reserve and complying with that document.
Thank you very much.
Mhm.
So, you know, I understand, you had a reserve study done, they would come in and say, yes, you would need this portion for deferred maintenance, this portion for a single landscaping thing, you know, any initiative that would be a big, well,
So usually if it's ongoing landscape, like ongoing expenses, that's not gonna be part of your reserve study, because that's part of your budget.
the
If-
landscaping, for example.
Right, if you come in and you say, we have this entire area that we use these ornamental trees, and the life of a tree is, you know, 5 or 10 years, then you can ask them to include that in there. But the reserve study in and of itself is going to be about the life of components, and in order to have that component in the reserve study, you have to identify the life of the component. So you wouldn't use something like, we have this big project because we know we need to come in and plant grass and then mow it weekly, right? Because that would be more of a budgetary ongoing expense. And you had a question?
In our governing documents, it actually states that the homeowners have to vote on reserve usage. And so that would also be something that you need to check in your governing documents, because
It's a good point.
we can't use our reserves unless that's voted on.
Yeah.
One more quick question. The certified mailing thing.
Mm-hmm.
Our management company has been trying to charge us a ton of money for it, and certified mailings really are pretty cheap. At one point, I thought I read that they could only charge what the actual cost was.
Yeah,
What are you
so-
guys finding?
So the statute says it's the actual, it's a reasonable cost incurred by the association for the mailing. Now, there's a couple different, there's a couple facets to this. First of all, the association, if it is being charged $50 every time the management company mails a certified letter, then that is an actual cost to the association, right? Whether or not a court would agree that that's a reasonable cost, I don't know. We haven't had a court kick that back in particular. What we have had are a lot of news articles about management companies, news articles, writing articles in such a way, that are written in such a way that say, hey, this company is charging $50 and it only is $3.05 to mail a registered letter. And so that was actually 2 years ago. That created a huge storm in the Capitol, actually, in the legislature, because then it became kind of center focus. The other facet that you need to think about is that the contract that the association has with its management company and the costs that the management company are passing along to the association, that's a contract between the association as the corporate entity and the management company. The owner didn't sign up for that contract, right? So it is also possible that a court can say, you can't pass this along to the owner, the additional, so not the registered fee, but the additional fee that the management company is charging, because the owner signed up to be in the association and agreed to this document, and that's a contract that the owner isn't privy to, because that's between the corporate entity and the management company. Now, that has not come up yet that I'm aware of in our state, but it's something that constantly hangs over us. So I would be very, very cautious, and before you sign any of these contracts, not management, I'm talking any contract across the board, strongly recommend getting it reviewed. And a lot of times what I hear back is, well, the contract was only for $5,000 and you guys are gonna charge, you know, however much to review it, which is true, right? It's expensive to have a contract reviewed. However, your exposure, if the contract does not go well for you, is that's where the money's beneficial. Because you might have a contract that says, You can't get out of it, only the company can terminate it. You might have a contract that says, well, I will pay the remaining 3 years of the contract if I terminate early. That's where it comes into play. All right, I've taken up enough time and Melissa's falling asleep, so I'm going to turn it over to her. Thank you so much for coming. I'm so sorry.
No. Okay, I'm moving on to recommended policies. Amanda was addressing all those policies that are required by Colorado law, and I'm shifting on to what we recommend as an associate, as a law firm. And the reason why we recommend these is really because these are the issues that come up all the time with our firm that could cause boards to be exposed to liability, or they don't know how to treat the certain process and they start treating it hodgepodge and everybody's doing something differently. So we try to alert you to certain policies, and these are 10 of them. There's others on our website as well, but these are 10 of them that come up quite a bit. And just really quickly to talk about that reserve thing and using the reserves, that question comes up all the time. Do not do that. Do not take money from the reserves and use it, because it's earmarked for a certain reason. And if you take it and pay it for something else, then you're exposed to liability as a board for inappropriately managing your money, because they've been saving the money for the last, 2 or 3 years, and then you take it to pay a snow bill. That doesn't make any sense. You know, if it's an emergency, that's one thing, and let's say it's an absolute emergency and you have no other funds and you must pay this expense, okay, that's a very extreme circumstance, but you would then want to have a very aggressive payback schedule and replenish what you took out. Otherwise, again, those funds are earmarked for 5 years from now, and they're going to be gone because you've taken it, and then you're going to have to levy a special assessment or get a loan or something like that, which you don't want to do that. Okay? All right. So I have 10 policies to talk about. Some of these are pretty simple and some are kind of complex, but again, these are things that come up quite a bit. So let's talk about cameras. Camera policy. So first of all, this is coming up a lot because a lot of people have the Ring cameras now, and sometimes we have homeowners that want to install cameras on the common element building because they want to, focus on whatever. So let's first talk about the question that often comes up is that even legal to have a camera and have it pointing out to the trash cans or whatever, or pointing at me? Can somebody come outside and take a picture of me? So just note this is a myth. Everybody thinks that there's an expectation of privacy outside. There is not. Anyone can take a picture of anyone outside. You don't have an expectation of privacy when you're out in the public. So someone can take a picture. They can even take a picture, and this is wrong, I don't like this, but they can take a picture of your child they're playing because they're out in a public space. So don't automatically think that you can't, that you can ban cameras from being installed, okay? Just on the idea that there is a privacy issue. But let's kind of split it between cameras that the association is going to install and then owners who want to install cameras. Okay, so first let's talk about association installed cameras. So typically, does anybody have any cameras in their community? Okay, where is this the association installed camera?
No, it's mine personal.
Okay, anyone with an association installed camera? Okay, and where is that camera?
Looking at the dumpster,
Okay, so why did you put it there?
because we were getting illegal use of the dumpster.
Okay, so violation, so compliance, you're trying to catch the person. That's absolutely correct, you can do that, and that's what most associations want to do. They want to prevent violations from happening because now there's a camera there, or they want to catch them, right? So that is a typical reason why an association would install a camera. But some people might think, oh, there's a camera there. And this actually happened with a condo association where somebody put a camera in the lobby and everybody thought that it was being monitored 24/7. And that if somebody committed a crime in there, somebody's gonna rush out and help them. That's not the case. The camera was there for compliance issues only. But they did not do what's necessary, such as adopt a camera policy, to say what was the purpose and use of the cameras. And they called it a security camera, which you don't want to do. You want to call it a camera. You want to adopt a policy saying we're installing cameras for violations, You don't want to imply if it's monitored 24/7 and you have that kind of a community and you do have security, well, that's one thing. Most associations don't have that. It's not monitored and they're just reviewing the cameras later for evidence of violations or, whatever. So make sure you don't call it a security camera, and make sure that people know why it's there so they don't have a false sense of security that they're gonna be saved. And it did happen with an association, not one of ours, but it was a condo and there was a lobby and a lady got mugged and the association got sued for essentially creating that false sense of security. She was not as self-aware. She wasn't really paying attention because everybody thought, oh, there's a camera. So that's something that you want to know if you are going to install cameras, which is a pretty common thing these days as an association. Adopt the policy and make sure you say where they are and what the purpose is for the camera and don't call it a security camera. The second thing is the records themselves, and this is kind of so it's up to you where you want to put it. So it could be the trash can, could be, the monument entrance, wherever it is. That's up to the board where they want to install it. But then the record itself, Amanda talked about the inspection of records policy, and there's certain records that have to be open for inspection. And this is not one of them. This is not an association record. The recording of a camera is not listed as one of those records that homeowners have the ability to request a copy. It is something that you should state in your policy. I actually printed out a couple of different ones that we've done. But you want to state that, this footage is not an association record. So nobody can just, oh, I want to see, and I want to see who's violating, and I want to do that. You can't do that. It's not appropriate for that. But it might be appropriate if, for example, maybe your vehicle got damaged and you know that there's a record that you want to turn over to your insurance, or maybe it's a criminal use, so somebody committed a crime and you want to access it for that person or for that purpose, then definitely put that in your policy that there will be exceptions for footage that is necessary for criminal evidence or insurance or that kind of thing. But in general, owners do not have, only board members and managers should have the right to use that footage. Time frame too. Some people think that you're going to have this record forever, and I know that one lady asked how long you keep records. That's really up to you, but some people will say, some boards will say, we'll keep the footage as long as we need it. So if it's for a compliance issue, they get rid of it after 30 days. If it's for monitoring contractors, for example, to make sure they're doing the correct job, they're going to keep it for that time frame. Other boards will actually state a specific time frame. We keep it for 14 days and then we scrub it. So just address the time frame that's within in your policy, because again, if they might need it for some criminal investigation, then they should be able to say, can you hold that? Because the cops might need this later and we want you to hold it longer, okay? Okay, yes?
In discussing the possibility of having an association camera.
Okay.
The subject of privacy came up in this regard. What about going and showing into somebody's window in an apartment?
Yeah, so if it is pointed at a window, that in itself, there's no expectation of privacy. You can shut the drapes. If it's clear that you're trying to look inside somebody's unit, so if there's no other way, I'll give you the Ring camera. The Ring camera might be pointed right at a window because that's the only place that they can see the footage for somebody coming in and trying to break into their house. So some ways, naturally, they're going to have to point it at a window, put up some drapes, But if it's the only way that somebody's going to be able to see into this window is if they use this camera and not, there's no, it's on the 5th floor and they're like, doing something unreasonable, then you could probably say it's an expectation of privacy that I can, on the 5th floor, have my drapes open and nobody should be able to see in. So it's kind of depending on the circumstances, okay? So the other thing I wanted to say really quickly about, so that's just association installed cameras. So the footage, purpose use in cameras, and then monitoring contractor performance. But the other thing I want to talk about was the owner installed cameras, because this is coming up quite a bit. People want to put the Ring cameras. You have to first figure out if you have even jurisdiction to say that they can't put the camera up. And with single family homes, typically there's not much in terms of what you can do as an association. Sometimes it'll say any modification to the exterior of the lot, you have a right to approve or reject any exterior modification. So putting a Ring camera on a single family home, detached home with acreage, you still have the ability to say, we can approve or reject it. But obviously you want to encourage it. Most of the time people have Ring cameras to address security issues. So you don't want to deny something like that. You would maybe want to deny it if an owner wants to take a camera and put it on the common area, because that's not within their jurisdiction. Doesn't mean you have to deny it, but there's more reason why you might not want to deny it. What are they putting it there? Why are they putting it there? But if it's on their home and it's a single family home, you have to look for language that says that you can approve modifications to the exterior. If there's nothing, then you can't approve or reject it. Different from condos. Anyone here in a condo? Communicate, you got a couple. Condos are different because everything on the exterior of the unit is a common element. Maybe it's a limited common element, so you have every right to regulate what's on there. And so in those cases, you can say, for aesthetics purposes, you can regulate it. But most Ring cameras are really tiny. It's not going to be an issue. And again, you just want to encourage the use of it, but be reasonable in terms of rejection. If it's something that they want to put on the side of the building that they have no reason to put it there, and they just want to look at people out in the public or whatever, then you can say no. And if they're saying, well, I think crime is happening, or I think they're using the dumpster wrong, well, then the association can install the camera, and it'll be an association enforcement issue versus a homeowner's. Okay. The other thing I wanted to talk about was complying with applicable laws. So if you have a policy that says, yes, owner, you have the right to install a camera, and you can install it on the exterior. It just has to be small. It shouldn't be pointing directly in a window if you can avoid it, and you have all these regulations. Keep in mind that in your policy, you should say that we're not approving anything other than the aesthetics, and that's it. You're responsible for complying with law. So the reason why I say that is because there's no expectation of privacy for images, but there is eavesdropping issues. You do have an expectation of privacy to your conversations. So I don't know the specific law, but I do know that you cannot record that conversation, and you can't use that. So there's certain eavesdropping laws. So you want to make sure that in your policy you're saying, yes, if you're going to install the camera, then we need to approve it, and if you have the jurisdiction to approve, but we're not responsible for your compliance with any other laws. That's up to you. You figure out the laws and you comply with them. Okay? All right. Okay, next one. Claims submissions. So claims, and also just, by the way, there's a great article on our website. It's called Smile, You're on Candid Camera, and it kind of goes through even more details of what I just talked about today. And so if you're considering getting a policy done or doing it yourself, just get on and check out that article. All right, so claim submission. This is really more appropriate for condos, I'm going to say, and some townhomes. Is anybody in a townhome here? Okay. Sometimes, because claim submission, why this is important is because what we found happening is when a condo or a townhome is going to want to file a claim on its insurance policy to cover damage that the association is supposed to cover, that sometimes the homeowners, if it's damage that's to their unit, sometimes the homeowners will go directly to the association's insurance carrier and file the claim. And if you don't have a policy in place that says, can't do that, everything is adjusted and addressed by the association, they have a right to do that because they are insured under the policy. Every unit owner is an insured under the association's policy. So one of the main reasons why you want to have this is to avoid an owner filing a claim themselves and getting the claim open, or their carrier, their own HO6 carrier, trying to circumvent some of the requirements that would be under the documents. So things that you want to put in there, and this is again, if you want to file an insurance claim with the association's property insurance, then this policy will say what are the steps that an owner has to take, and the board, in order to determine whether it's appropriate for the association to file the claim. Because sometimes it's not clear. And an owner might think, well, wait a minute, there's damage inside my unit, and it came from the association's pipe, so they kind of assume that it's an association issue, they file a claim. That's not necessarily true. Where the water comes from doesn't dictate who's responsible for repairing it or insuring it. So this type of policy will address that. So you'll go, the steps to be followed would be, first of all, determining who is responsible for the repair of whatever's damaged, determining who gets to investigate it, because sometimes, let's say it's in an owner's unit and the owner calls 20 different plumbers and incurs all these bills and doesn't discover where that water is coming from. And if the association was investigated, they might be able to do it really quickly and have it done and have a good claim. But the owner who does this might want to then demand reimbursement for all that investigation cost. This is the policy that would say, here's what you do when you see a water leak and when you think that the association has an insurance claim, here's what you follow. We're gonna investigate it. We're gonna send out our contractors and we're gonna address it. Here's the information you have to provide to us. Here's the requirement that you have to do this quickly, because that in itself could, if they don't respond quickly with information or access into their unit, then that could exacerbate the problem. So there's a lot of things that you would put in on the front end of this policy. Then you would state the steps in case there is a potential claim against the association's policy. And again, it would be the association determining whether it's appropriate. There's a lot of questions you have to ask before you actually file a claim. And you need to make it clear in the policy that the association makes that determination. This is this second piece too, this requirement of the owner and their HO6 agents to follow the process, that's very, very important as well. Because they, again, might jump the gun and just automatically file a claim when the association would have determined that it's not an association claim. So that's the kind of thing that you want to put in here. The other thing for condos, I know there's a couple of you in here, what I've seen sometimes is in a condo, if there's a damage claim and the owner's HO6 carrier and their agent says, oh, it's a condo. Condos are automatically insured by the association as the primary insurance, which means the association's policy kicks in first. That's an automatic assumption with many owner carriers, and that is just not true. So sometimes it's a requirement, sometimes not. It's going to depend on the type of association you have, when it was created, what your documents say. So again, this kind of policy would clarify that and say, the association, that the owners and the HO6 agents have to follow this process. And it should also say who pays the deductible. So if it is clear that yes, this is an association property insurance claim, the deductible is the amount that the association is responsible for before the insurance proceeds kick in. Sometimes that's $5,000, sometimes $10,000. The policy should say who pays that deductible. And a lot of associations will have the unit owner pay if the damage is to their unit. And a lot of them will say common elements is always going to be a common expense. Deductible goes to the association. But it's when there's negligence, there should be something in there that says if the owner's or the association's negligence caused the claim, then that deductible should be shifted to the negligent party. All of these things should be included in that policy. Okay? All right. Document retention, and on this one, I was gonna, Amanda had mentioned how I would talk about specific time frames
Can I screw you up?
No, I
Okay.
wanted to show the permanent ones. So a document retention policy, it's not required, but it's absolutely recommended because you want to know how long to keep those records. And unfortunately, Colorado law does not say much in terms of how long to keep these records. It only specifies certain timeframes for certain records, and there's only few, like maybe less than 20, and there's a ton of records. But the inspection of records policy that Amanda talked about, that particular part of the statute, if you want to write this number down, this is the statutory, the statute in Kiowa, the citation, that lists all those records you're supposed to keep. It is 38-33.3-317. 38-33.3-317. That's the inspection of records policy. There's probably 4 or 5 records where it actually says, you must keep this for 7 years. That's the tax records. You must keep this for 3 years. That's any communication that has to be sent to all the homeowners. You must keep it for 1 year. Any sort of ballots and proxies that lead up to that are in an election. So there are a few timeframes in that particular statute. I did want to point out that there are some records that must be kept permanently. And those records are in the Nonprofit Act, actually. And so those are minutes of all board meetings and all owner meetings. So the annual meeting minutes and the board member meeting minutes. Permanently means permanently. Okay, so it doesn't mean you have to recreate things that you didn't have before. But to the extent that you have them moving forward, you should have minutes and keep them permanently. Doesn't mean you have to keep hard copies. You can keep them electronically as long as you can easily convert them to a hard copy if somebody requests. So that's one of them. The other one is all actions taken by board members outside of a meeting. What does that mean? That's email votes. So if a board decides to take a vote by email, then that action, like for example, hiring a landscaping company, and they don't do it at a meeting, they just decide to vet it via email, and then they make a decision via email. That decision, saying whoever voted yes or no, those records showing that decision must be kept permanently. Not the emails all leading up to it, just the decision, saying we approved this or we rejected it. However, as Amanda said, all those emails leading up to that decision by email are open for inspection for 1 year. So you have to at least keep those for 1 year. So I'm throwing a bunch of time frames. Again, there's only a few. The rest of the records, there's so many records, it's up to you to determine how long you want to keep them. We typically draft these policies, I think maybe it's 260, but what we do is we establish best practices that we've determined this is a good amount of time to keep these types of documents, and we go over all the documents. So you should do that, because then we only have to keep that document for 1 year, and then you have someone, usually the management company, that will purge it. Every year they purge it. They say these are the documents that have to be destroyed, and then they destroy them. Then you're not left exposed to potential liability if you keep records forever and ever and ever, and all these boxes, in some hall somewhere, where somebody's trying to establish liability, and you might have records out there, you might have to go searching. If you have a document retention policy, then you can say, oh, any contracts have been destroyed that are over 4 years old, for example. So it's a great policy to have. Again, it's not something that the association is required to have, but we absolutely recommend it. Yes?
So even when you ratify it at the next board meeting, that's not enough, you need to keep that final email.
Yes. And that's just the decision, right? So not all the emails lead to it. Yes?
What our board tends to do is they don't ratify, they may approve something online, but then we go through the process of having it again, a motion made and seconded and approved. So is that okay?
Yeah, I mean, what you want to do, what the statute says is you're supposed to take that decision and at the next physical board meeting, attach that decision to your minutes. So it's almost the same as ratifying it again, but you still have to keep that record and you should keep it with those minutes of the next physical board meeting. Okay? Okay, and so there's a lot of other records as well, but just, and who, in your management contract or in the document retention policy, you should say who is responsible for destroying the records during, every year, which records are going to be purged every year. Typically, it's the management company, because typically the management company is the one that's maintaining the records. But that is driven by your contract. So be very clear about that and say what you're expecting in your contract. Okay? All right. Electric vehicle charging stations. Anybody getting these kinds of questions coming up for EV charging stations? So that has become a bit of it's starting to be pretty popular. And I always say to get ahead of it because, especially with the condos and townhomes, what you're required to do is if someone wants to install an EV charging station, so those stations where they can get that electricity, then you must allow it. And what the statute used to say is you must allow it within their unit boundaries or their lot boundaries or in a limited common element area, which is an area that typically the association owns and you have an exclusive use over it, like a parking garage that you might not own, but you have an exclusive use over. That was changed a few years ago to say any space, even a general common element parking space, if somebody wants to install an EV charging station there, then you must allow it. But there's a lot of conditions. And one of them being they're responsible for all installation costs, for all future maintenance costs, for any kind of liability if they did it wrong, for any electricity that's going to be used. And with respect to the electricity, if there's a way for them to just go straight through with some kind of pass-through charge through the system, that's the easiest. But let's say they have to be part of the common element grid, then the statute says you have the right to provide a flat fee, for example. You can talk to your electricity server and they can tell you, oh, okay, well typically it's going to cost X amount a day, and you can do that. So there's a lot of shifting of costs, maintenance, liability, insurance. All of this is shifted to the owner, and you can say, yes, you can install it, however, it's conditioned on entering into this written agreement that establishes all these specific terms, like the aesthetics, where they're permitted to install it, safety requirements, design specifications, using licensed registered contractors. Yes?
If a townhome owner installs that in their garage, which is their property, then why would it even come to the board?
Well, it's only if there is something in the declaration that says that, and again, this is like the whole camera thing. If you have the requirement before you make any modification to the exterior, and I don't know if the garage would be considered the exterior or not, okay, so then there wouldn't be any, because it's inside the garage, especially for single-family homes and sometimes townhomes. Sometimes townhome owners have separate garages, that's actually not theirs. But in your case, if it's a townhome and the garage is attached to your home and it's part of your townhome and there's nothing that says that you have to approve modifications to the interior of the garage, then you don't need to. But for what if they wanted to put it on the driveway, for example? Yeah, then it would be an aesthetic thing, or they wanted to put it on the general common element parking space. So again, you need to approve it if you have any kind of jurisdiction for approving, which often with single family home, detached homes, there's nothing. And sometimes with townhomes, there's nothing. The other thing is get ahead of this now for condos and townhomes that do have to approve it, because let's say the only place in a condo that you have to install this is the common element parking garage. You need to know now from your insurance carriers and engineers, how many can we install before it becomes an issue with the electrical grid? How many can we install before it becomes a potential fire hazard? That's the kind of information you want to know now, so that you can say, once we get to 5, we're not going to install anymore because it's no longer a reasonable request to allow installation, unless we change the electrical grid, which is going to cost a ton of money, and then you present it to the homeowner. Do they want to do that? But you want to have that information now if you have the situation where the only place they're going to install it is a common element garage or something that might be hazardous if you install too many. Okay. Flags and signs. So flags and signs has changed in the law at least 3 times now, where there used to be a requirement to allow, for example, political signs or allow American flags or certain types of flags. It's gone through different changes in the law, and now it's completely changed, and I think it's because boards were kind of in a pickle in trying to enforce or determine what was appropriate to allow as a sign or not to allow. So for example, if you if the sign said Black Matters or Black Lives Matter, and then there's Blue Lives or Blue whatever, right? Blue Lives Matter. Which one is appropriate for your community? Which one is objectionable? People were objecting left and right to these kinds of political statements, and it was putting the boards in a kind of a difficult position. So here's the state of the law today, which I think is probably going to stay this way. And that is, and you should adopt a policy on flags and signs to address this, but that is that the association no longer has any right to ban or regulate non-commercial signs. Commercial signs are things like for sale or contractor signs. So the association no longer has the right to ban or regulate non-commercial signs on the unit owner's property or in their window based on content, based on message. So what does that mean? You can no longer say, for example, political signs are allowed because that's a message. It's a type of sign. You're regulating based on content. You can no longer say something, as if somebody wants to put up a sign that says, I hate the management company, you cannot regulate that. You can say, okay, I hate them too, or I love them, or whatever, but you cannot prevent them. They could put up a swastika sign, and that's not something you can regulate. Now, there might be some local ordinances that you might say, this is a nuisance, or this is something hate speech. Then you can defer it to the city or to the local government, but you no longer, as an association, can ban or regulate based on content. What you can do is adopt content neutral regulations like size of sign, number of signs, placement of the sign, location. The signs have to be professionally written. No, whatever, scrubbing of whatever. So that's what you can do now for signs. You can no longer ban or regulate non-commercial signs within the unit or lot boundaries or in the window. It specifically says windows because that's really condos, because the condos, the windows are typically not considered the unit, so they want to say they should be able to put up signs in their windows. But if it's a commercial sign, then you can do so. You can do whatever you want. You can say no for sale signs. As long as your documents allow you to regulate signs, you can say no for sale signs, no contractor signs, or signs, contractor signs can only be put up within 30 days after the construction is over. So you can still regulate how you want to for commercial signs. It's just the non-commercial signs that you have limitations now. Yes?
You say within 100 units, so if somebody puts something on their balcony, it's not a window, but it's
Right.
on a balcony.
You can still regulate and say no, not on the balcony. For signs, if you look at the next one, flags, it's within the unit boundaries, in the windows, or on the balcony. So it extends that to flags because a lot of people want to have the flags drape over the balcony, or maybe a little flag that's stuck on the, with a little flagpole. So here, the reason why you want to adopt a policy is if you don't adopt content neutral regulations, then come political season, come election time, they can put up 20 signs because you didn't adopt a regulation. And they could put it, like, let's say there you have a single family home, the lot boundaries as the entire lot, they can put up 50 signs because you didn't adopt a regulation saying only 5 signs or only 2 signs or whatever. Okay. The other thing I wanted to mention real quick is, and we already talked about the fact that it's limited to windows for signs and unit boundaries, and windows, unit boundaries, and balconies for flags. It does not extend to any other type of common element. So you can always say no signs at all on the common elements. And common elements are the property that the association owns, okay, or that is all the unit owners own together. So just, the policy will help you treat everybody uniformly. That's why you want to have this in place, particularly because certain things come up, election season or whatever, and you would want to have this in place ahead of time to show that, here's the rules, follow the rules. Okay. Reasonable accommodation and modification. So this has to do with the emotional support animals, that kind of thing. Like somebody needs an exception to a rule because they're disabled. So let me just speak about that really quickly. Reasonable accommodation, reasonable modification means we want an accommodation to a rule or restriction because of our disability. So and it's protected under the Fair Housing Act. Fair Housing Act prescribes a number of categories that are protected from any kind of discrimination, and one of them has to do with disabilities. If a person is disabled, then you as an association must grant them a reasonable accommodation or modification to your rules. As an example, and first of all, real quick, disability is very broad. It could be the obvious disability, somebody's mobile disability and they're in a wheelchair, or it could be something like severe anxiety or PTSD, okay? So the Fair Housing Act, for example, if you have a person that wants to install a wheelchair ramp in front of their townhomes, typically you wouldn't allow a ramp in front of the townhomes. It's not aesthetically correct, but they need that to access their home, so you must grant them that reasonable accommodation. If you don't, this exposes associations to liability pretty quickly, and there could be some pretty hefty fines because both Colorado and federal law really want to protect disabled people. So you need to really understand the ramifications for not complying and what you need to do in order to ensure that you are granting it correctly or rejecting it. Let's say you want to reject something, it better be within the law for you to reject it, and that's what this policy would address. And reasonable accommodation is an exception to a rule. Reasonable modification is exceptions to the architectural type things that you would allow. So this policy really ought to include the process for requesting it. So you don't need to guess. They need to say, I'm disabled and I want you to grant this exception to me. So that should be in the policy, is that process. Criteria for determining whether the request should be granted. Now that's probably the most difficult part, is do I grant this accommodation? When we see the emotional support chickens, for example, on the plane, or you see, whatever it is, you think, is this person just, gaming the system? Should I really do this? This policy will set forth the criteria of what you should ask. So, just so you know, if a disability is obvious, you cannot ask them for proof that they're disabled. So if they, for example, let's say you have a rule that says no dogs, and you have a blind person who is obviously blind, and they say, I need a seeing eye dog. That's pretty obvious, you grant it. Put it in the file, get their request, put it in the file, you're done. But let's say somebody has PTSD. You can't tell it. They could be just saying it's not obvious. So Disabilities that are not obvious, you do have the right to request some documentation from a healthcare practitioner, which is a very broad term. Could be a doctor, could be a social worker, could be anybody that could establish that yes, they are disabled and yes, they need this accommodation. So you do have the right to ask that. Once you get that information from the healthcare practitioner, then you, again, questions are done. You don't ask anymore, put it in the file, grant the accommodation. But there must be something saying, yes, they're disabled, here's their disability, and yes, they need this dog or this cat or whatever the reasonable accommodation is. Now, I say reasonable because if they say, I want to bring my pet hippo into this condo, you know, that's not reasonable. Or they bring in a dog that starts biting everybody and injuring people. That's not reasonable. So again, there's a lot of things to consider, and that would go into the policy. Time frame for response, you always want to respond very timely. Even if you're not sure and you have to get this information, you want to open a dialogue really quickly and show a paper trail that you're trying to comply and to address whether the accommodation or modification is correct. Okay? Because again, the CCRD, which is a Civil Rights Division, Colorado Civil Rights Division, they are very aggressive, and they want to see that you're trying to respond and you're trying to open that dialogue. So start the paper trail quickly, and this policy would be a great thing to have so that you would also have the forms that you can give them saying, who's your health, who do we send this to if we need documentation? Well, what's your disability, and put it in the request. If you put together the policy and they don't want to use the form, that's fine, because as long as they give the information that you need in order to make an informed decision, they can just have their doctor send whatever, as long as it establishes disability plus the need for that particular accommodation. And then finally, I wanted to quickly talk about the difference between accommodation and modification when it comes to costs. So typically with accommodations, there is no cost. It's just let me violate this rule because I need to violate it in order to have equal use and enjoyment in the community. There's no cost involved. It's just the cost of saying that rule won't apply to you. But modifications, there's often a cost. To install whatever modification is requested, that's at the cost of the owner or the person who's requesting the modification. And it doesn't have to be an owner, it could be a tenant. It could be somebody who is requesting it because they are considering moving in, so they're just potentially an owner or potentially a resident, but they pay for it. Now, if they leave or no longer need it, and the modification is to the exterior, like a wheelchair ramp or some kind of railing, you don't have the right to ask them to remove it. That's something that's key under federal law. If you want them to remove it, then you have to pay for the cost. And there's the justification in many cases is maybe it's because other people might want to use the ramp and that they're disabled as well, or the railing is good for safety, but you cannot ask them to restore it to original condition on the exterior. If you want to restore it, then if they voluntarily restore it, great. But if they don't and they leave, then and you want it out, then you can take it out as an association at your cost. So all of this is in the policy in order to address the emotional support animal or any kind of reasonable accommodation or reasonable modification request. Yes?
Do you have samples of all of these documents somewhere?
We don't, but I'm going to tell you. And you know what? After this class, we'll send to you some of the things that we provide if you wanted us to draft one. But I will tell you this excellent statement that if you just Google this, so the enforcer of the federal law for the Fair Housing Act, it's both HUD and the Department of Justice. So if you Google HUD/DOJ reasonable accommodations, it's going to come up with this great memo, the statement that says, here are all the questions that we get on reasonable accommodations. It's gonna say things like, what's really a disability? It's this broad. Is anxiety a disability? Is drug addiction a disability? And it's also gonna set forth examples of who can provide that documentation and all the questions that come up. What if somebody wants 2 dogs and there's no dogs? Well, if both dogs are needed to address some form of disability, you have to grant it, you know? So it's a great statement that goes over all these different scenarios, and I would suggest getting that, okay? Okay, solar panels. So solar panels are, again, protected under Colorado law, and you have to allow them, but it's only to property that the owner owns. So for a single-family home, detached home, not the townhome, but just let's say it's a single-family home. They own the lot, they own their house, right? So you cannot ban solar panels from being installed on their property because they own it. You can adopt aesthetics regulations and for the placement and the dimensions and so the look of it. So you can say no huge solar panel on the front yard. It has to be on the roof, has to be flush, you know, those kinds of things. As long as whatever your rules and regulations don't increase the cost by 10% or decrease the performance by 10%. That's what that 10% rule is, okay? So that's for single family homes. And again, you have to allow solar panels on property that people own. Easy for single family homes. So what about single family detached homes? The owner still owns the townhome. They own the lot that the townhome is located on, but the association maintains typically the exterior like the roof. In those cases, you still have to allow it because they own the roof, even if the association maintains it. But in those cases, hopefully there's some language in your documents, but even if there isn't, I think it's reasonable to say, okay, yes, we understand that you are allowed to put solar panels on the roof that you own, but if you damage the roof, if you install it incorrectly and it somehow increases our maintenance costs as the association, if we need to get to the roof or replace something, then you have to take off the solar panels and put it back on. It's reasonable to ask them to condition approval on them entering into an agreement saying, yes, we understand that this increased maintenance liability is going to be shifted to us if we don't do it correctly, okay? So in that case, the townhome owner owns the roof, so you can ask, you still have to allow it, but it's reasonable to ask them to enter into an agreement, shifting maintenance and increased costs and all that onto the owner. So finally, we have the condos. Condos, no owners own anything on the exterior. They don't own their roof, they don't own their balcony. Those are owned by all the owners together. So you can say no. You have every right to say no solar panels. Or you can say yes, but we condition it on a bunch of other things. You know, so that depending on the community you live in, your regulation authority over the solar panels will be driven, you know, by whether you can actually say no, or you have to say yes, but condition it on some reasonable things. And the policy would again address all of that along with an agreement saying we condition approval on X, Y, and Z. Okay. Towing and immobilization. Hold on a second. This one, towing laws have gone through so many changes. And the thing is, with the towing laws, the regulations are really more on the towing carriers and the mobilization carriers with the boots and all that. They're on them. They have to follow a bunch of regulations. I'm not going to tell you what all those are. I mean, I'm going to tell you the article to look at on our website. It's called Here We Tow Again, Towing Regulations Governing Community Associations. You can always get that article, and it kind of spells out. But there's a ton of new regulation. And I want to just go over just generally what should be in this policy, and then again remind you that it's the towing carrier that has to follow all the stuff, but the association should know about it. So number one, lots of new laws, but There has to be some kind of written notice prior to the towing and immobilization. So typically, if you're going to tow, and this is only on private property, on the association's common elements. Remember that Amanda said you can no longer enforce on public streets. That includes towing. You can't tow, you can't fine them for enforce what's on public streets. But if you have a common area parking lot, any kind of limited common element or common area, you can regulate on those areas, and you would be able, one of the remedies is towing. So if you have a common area parking lot at a swimming pool and they've parked their RV there and that's against the regulations and sitting there for 2 weeks, then you probably have the right to tow that vehicle because it's a violation, but you should do it according to the policy. So the policy is going to require written notice, which typically means just, the ticket that's put on the windshield. Excuse me. But again, the notice regulations, there's tons. The written notice has to comply with a lot of information. It has to say, the vehicle will be towed if it remains parked inappropriately, a description of the reason the vehicle is parked inappropriately, the time the vehicle will be towed, all this language that's now driven by statute. So your notice and your ticket is something that the towing carrier will probably provide to you if you have a towing company that you enter into. So that's one thing, the new notice requirements. There are certain types of violations that you don't need to give any notice. I mean, the statute says at least 24 hours notice. That's what the statute says for those types of parking violations that don't fall into the exceptions, which we'll talk about here in a second. At least 24 hours notice. However, you need to look at your governing documents, your declaration, because sometimes they'll say at least 72 hours. And if your documents give more notice, then you have to follow your documents. But if it doesn't say anything at all, at least 24 hours notice before they can tow. Certain violations, you don't need any notice at all. Things like it's blocking the driveway. It is parked in a handicap space. You have limited common element parking spaces and somebody's parking on yours. It doesn't have a tag if you're required tags for your community. So there's a number of them, again, it's in this article, about what you can tow without any notice. But again, look at your documents, because your documents might say 72 hours, 24 hours. If it does provide notice requirements, follow your documents. If it doesn't, you can follow the statute. There's signage that has to be posted now. And the signage, I mean, things like not less than 2 square feet in size, the lettering not less than 1 inch in height, has to be pointed a certain way, has to, I think, be both in English and Spanish. So there's all these requirements. Again, your towing company would be the one that is providing you the signage and making sure that it complies. The other thing that the new law says is you can no longer tow, and this is even if it's in your declaration, you can't tow just for expired tags. You probably have something in your documents that says parking a vehicle with expired tags is a violation. Well, it's still a violation, but you can't tow just based on that. That's per statute. Oh, and then one last thing I wanted to mention was that you used to be able to just give the towing company the ability to go through and monitor and see which ones were in violation. They can no longer do that. That has to be you or your management company. And the other thing is too, 24 hours prior to towing, you have to actually sign off on a written form, permission for them to come to tow prior to each potential tow. It's not like you can say, here towing company, here are all the ways you can tow, and we'll just call you when we see a violation. No, you have to sign something saying, we authorize you to tow. And there's a form that the towing commission has provided that's on their website, that you just follow that form. So there's, again, tons of regulation. There was also a bill with immobilizing too, the booting and everything that's pretty similar to the towing. If you are considering towing as a remedy, because there's other remedies for these, you can fine them, you can do, fining doesn't work that great if they cure it within 30 days, as Amanda said, they have 30 days to cure it, so if they move the vehicle, it really doesn't do anything. But if you want to consider towing or immobilizing a vehicle, then talk to your attorney and make sure you get a policy in place that spells out what you can or cannot do. And make sure your towing company, there's only a few now in Colorado because they all left the state because nobody wants to follow all those compliance regulations. Okay, we got 2 more, I think, and then we're done. Water leak. This is really more for, again, condos and townhomes where you have a lot of water intrusion issues. That's pretty common in Colorado. This is the best policy because what it does is it requires the owners and the board to follow a very clear process for whenever an owner sees a water leak, maybe sees a watermark or any evidence of water intrusion. Here are the steps they follow. Who do they call? Who gets to investigate? What kind of information they have to provide? The determination of the ultimate responsibility for repair and negligence and all of that. Who pays for investigation of that leak? Because oftentimes the condo association, we don't know where it's coming from. We just know there's a leak. So you should have a policy in place that says the association is the one that goes in and investigates, and if it turns out that the leak is coming from somewhere that's not an association maintained component, then the cost for investigation can be charged back to the unit owner who has the component that failed. So this kind of thing spells it out. It keeps it within the control of the association because, again, we don't want owners not knowing what to do and everybody's calling everybody else's vendor and people there's double work being done, double expenses. It's best to have the association control the investigation, get the report, and then if it's appropriate, assume that investigation cost or charge it back to the homeowner whose component failed. And much of this is in your documents, and if you have a water leak policy, you would then clarify what's in your documents and establish the step-by-step process. It works really good in conjunction with that insurance claim submission policy because it's usually for water leak intrusions. Okay, finally, xeriscaping. So xeriscaping, like towing and like flag and signs, went through a metamorphosis when it comes to law. And now the law has changed once again. It hasn't changed in a couple of years, but so I think this will stick. But just in general, xeriscaping must be permitted. I mean, this is a state that it's public policy. We want to have water conservation. It's something that is driven by the statute. And Kiowa, the statute that governs most associations, say that you have to allow the xeriscaping on property that the owner owns or is responsible for maintaining. So typically with single-family homes, it's their yard, If it's a condo, typically they don't have any responsibility on the exterior, so it's going to depend on the type of community you live in. That's still the law, is that you must allow xeriscaping and certain drought-tolerant landscaping. That's still the law today with respect to single-family or attached homes and condos. It's the same thing. All it says is you must allow xeriscaping if it's within these boundaries, and it didn't really stray from that. What happened was for single-family detached homes, it changed quite a bit. So these are the regular single-family home lots. What happens now, well, first of all, really quickly, before we talk about the new things that the single-family detached homes have to comply with, you should have architectural review guidelines saying, okay, if you want xeriscaping like any other landscaping, you have to get approval, and here are things you have to do, here's the process, here are the forms, here's our aesthetics, and whatever kind of xeriscaping guidelines you want to put in there. So what's new is for single-family home detached communities, which are the standard single-family homes, there's now a couple of new requirements. One of them being you can't ban artificial turf in the rear yards. So cannot ban it. You can still regulate it, so you can say, well, we like this kind of look of it or whatever, but you can't ban it. You cannot, in your guidelines, unreasonably require use of hardscape on more than 20% of the landscaping area. So that's a pretty specific requirement, and we haven't really seen many issues with this xeriscaping law, but still, that's not the biggie. The biggie, well, the artificial turf is kind of a biggie. The next one, you cannot prohibit homeowners from putting vegetable gardens in the front, back, or side yards. So you must allow them. And you can, again, regulate the look of it and the aesthetics, but you can't ban certain types of vegetables, for example. They have to be allowed the vegetable garden. And here's another one. You must adopt 3 pre-approved water-wise garden designs for installation in the front yards. Again, we're not talking about condos or townhomes. We're talking about single-family detached homes. And you have to have this in place. You have to adopt 3 designs. Now, there are downloadable designs that you can get in a lot of different places, so it's easy to do that. But this is intended to replace the need to get architectural review approval if they choose one of these pre-approved designs. And you have to put it on your website. You know, if you don't have a website, portal. If you don't have a portal, then attach it to your policy and say, here's our xeriscaping policy, here is our 3 pre-approved water-wise garden designs. And again, not for condos or townhomes, just for single-family homes. So that was the broad summary of xeriscaping and what's required. If you get on our website, again, there's a article just on xeriscaping, and I can't remember what it's called, but yes.
When you say garden, are we talking vegetable, or are we talking flower, or are we talking?
We're talking water-wise garden designs. So not the vegetable gardens. The vegetable gardens, you don't have to have pre-approved sample vegetable gardens. What you do have to have is pre-approved water-wise garden designs, and that's the xeriscaping. That's the drought-tolerant type of thing. Now, the statute itself provided a link, and it's on our website, to where you can get sample downloadable designs. And you can take a look at those, but all these entities have them on there, all the governmental entities. I don't know, does Greeley have downloadable designs, do you know?
I don't think so, but if you have questions about that, let me know, because I know we have a website that has lots of information about clients that are good in Greeley, and then also there's a water district office in
Yes.
Berthoud that has.
There's a ton of places.
Designs.
Yes.
If you get garden in a box, that comes with the design.
Okay, yeah. So there are a lot of places that you can get these designs and download them and put them on your website. But all of these requirements and statutes and everything are on our website, and there are samples. There's a link that you can actually find some samples. And that is it, guys. 10 minutes to go. Thank you. Any questions? Any last questions? I know it's late. Man. Yes.
One quick question.
Yeah.
We were talking about insurance.
Yes.
And mainly like in condos and stuff, and a single family. But why don't you have a roll of cottonwood trees?
Mm-hmm.
Several of the big old cottonwood
Mhm.
trees. And they're on a common area. And one of those big branches falls on top of the house in the residential or a fence or whatever. Responsible.
Typically, it's the owner of the property where the fence or the tree fell on. They have insurance to address it. If there was negligence and not a catastrophic, like an act of God or something, then they could probably go after the association. But if there's no negligence and it's just a wind or something, then it's typically the owner of the property upon which it fell. Yes.
Is there any guidelines for use of insurance? What I'm thinking about is, we had a roofer cover up a hole with just the tar paper and the tiles.
Uh-huh.
The new owner saw a water leak in the upstairs bedroom and reported it before she purchased the property.
Okay.
So we're going back to the roofing company to find out why they would just indiscriminately cover up with paper and shingles. And then whose responsibility is it? Because it's a...
Of the leak, if they found a leak or something, or found something?
Yeah.
As Amanda says, you're gonna hate this answer, it depends. It's gonna depend. Where was the leak? Who's responsible for the component that failed? Was there negligence by the contractor in doing something that caused the leak? It's all gonna depend on the facts and the property that was damaged, and, you know, whether somebody was negligent. So it's gonna depend. There is a article on our website called Who Pays for Wet Leaks? That lays out exactly what you want to do whenever there's a water leak, and how to figure out who repairs what and who's responsible.
We're
You're
also
welcome.
gonna write an article called It Depends.
Yes, that's our next, that's our holiday article. It depends.
That's our holiday
But
article.
it's not for older people who.
Yeah,
Yes.
that's a second article.
Yes, yeah, it depends. Thank you so much, everybody. Thank you so much for coming in. If you have any questions, come on up.